Good evening. It is such a great pleasure to welcome you all to Monash Law Chambers for this very special occasion, the inaugural Professorial Lecture of Professor Melissa Castan. For those I've not met before, I'm Stephen. I'm the Dean of the Faculty. We are joined this evening by our faculty colleagues, by a number of our law students, by senior and very distinguished members of the judiciary, the academy, and the legal profession, and just as importantly, by many of Melissa's friends and family, including her husband Rob, son Theo, and her mum Nellie. I can see in the audience at least two Chief Justices, but I cannot see the puppies that turned up unexpectedly in Melissa's garden this afternoon. Hopefully they'll be at the drinks after the talk. We are meeting tonight on the unceded lands of the Wurundjeri Woiwurrung people of the Kulin Nations, lands which have been home to learning, to curiosity, and to connection for tens of thousands of years. Let me pay my respects to elders past and present. Let me extend those respects to all of our First Nations guests here tonight. So an inaugural lecture is always a highlight in the life of a faculty. It is a moment to recognize a scholar's standing and achievements, a chance to pause and reflect on their journey, the ideas, the impact, the community they've helped to build in their career. It is a chance for us as a faculty to show off. We get to say, look at this brilliant person. She is one of us. Melissa's journey with law and with Monash law runs deep. It began as a Monash law and art student in the early 1990s. Even as a student, Melissa was involved in questions that go to the very heart of justice. Working with her father, the late Ron Castan, on the Mabo case, that landmark case changed the legal and moral landscape of Australia, and it clearly shaped Melissa's own understanding of what law can and should do. That sense of law as a living force for recognition, for dignity, and for justice. Over the past 3 decades, Melissa has become one of Australia's leading scholars in constitutional law, Indigenous rights, and human rights. Her work has shaped legal thinking, informed public policy, and helped educate generations of lawyers who now understand that the law's true power lies in service to others. Melissa's scholarship is world-renowned. Her book with Sarah Joseph on the main United Nations Human Rights Treaty is the reference text on the ICCPR. Found in nearly 900 law libraries, it is cited by courts across the globe. The High Court of Australia, the European Court of Human Rights, the UK House of Lords, and the Hong Kong Court of Final Appeal. It is hard to think of another Australian text with such international reach. And that is just one bit of her extraordinary body of work. Melissa has written or edited 8 books, more than 80 scholarly publications. She has secured more than $1.8 million in competitive research funding. That's a phenomenal figure for our field. And what is so impressive is how Melissa's research translates into impact. From her funded work on Indigenous birth registration, to complex questions about free speech and academic integrity, to shaping the national debate on the voice to Parliament, to supporting Australia's first statewide formal treaty with First Peoples, Melissa moves her work and her skill beyond description and analysis to change. That sort of impactful research and engagement is very, very hard to do. In education, Melissa's impact has also been profound. She's co-authored some of Australia's most widely used textbooks. She's led curriculum reform, done innovations, and she builds learning environments where our students learn not just to practice law, but to think critically and ethically about the kinds of lawyers, the kinds of citizens they want to be. It is everything that Monash law aspires to be and to do with our students. Melissa's given a huge amount of herself to the faculty, director at the moment of the Castan Centre, formerly Associate Dean Education, Associate Dean Staffing, and as Director of Equity and Social Inclusion. Outside of Monash, she also leads in various spaces, serving on advisory boards like the Academic Reference Group of the Australian Judicial Officers Association and the Victoria Police Human Rights Advisory Committee. She edits the Alternative Law Journal, and she sits on the board of the Victorian Law Foundation. Melissa embodies what we mean when we talk about Monash law values. She is intellectually fearless, socially engaged, and totally committed to making a difference. Her career is a reminder to all of us that law can be a force for justice and that scholarship at its very best is an act of service. She uses her research and her platform to amplify others, to make space, to listen, and to lead by example. Since I became Dean at the start of the year, she's also been a very kind and trusted, wise counsellor. She's always ready with a very gentle, "Now look, Stephen, the thing you need to know is..." Tonight, we celebrate not just a distinguished professor, but a brilliant colleague, a brilliant teacher, and a brilliant leader whose work continues to shape how we think about law's role in building a better and more just society. So please join me in welcoming Professor Melissa Castan to deliver her inaugural lecture.
The puppy story is true. All the rest, he just made that up. Thank you, Stephen, for that very warm and extended introduction. I asked you not to do too much, and now I feel quite emotional and quite exhausted by that. So thanks again. I also would like to begin by acknowledging the traditional owners of the lands that Monash University teaches on and that we're meeting on, the Bunurong and the Wurundjeri Woiwurrung people of the Kulin Nations. And I want to pay respects to elders and leaders past and present who have fought tirelessly for justice and recognition as peoples and as nations in their own country. And I pay respect and recognise all the First Nations people who join us tonight or who watch the recording of this one day in the future. So my topic tonight is when life meets law. So let's start with an origin story. So I feel like Spider-Man now. 50 years ago this day, I was... That's my mum laughing, okay? So it doesn't actually count. 50 years ago... Wait, I have to do this bit. It's a bit. 50 years ago this day, I was playing outside our house in Leafy Kew on the nature strip. In those days, children were allowed to play by the side of the road unsupervised. My father came home from work, got out of the car and slammed the door. Clearly, he was very angry. He was not a very volatile person. This was out of character. So I asked, on behalf of my sister, I think, and I, "Dad, what's wrong?" And he said, "A very bad man has sacked the Prime Minister." And without saying anything further, he stomped inside. And I sort of have this memory of the briefcase sort of being flung, but that couldn't happen because why would he fling the briefcase, as he got out of the car? So I've recreated that bit. But the story is true and my witness is here. So I didn't know what sacked meant. I didn't know what the Prime Minister meant. I didn't know what a bad man was or who the bad man was. I only knew that a bad man had done something very bad that was very upsetting. Of course, what he was talking about was Sir John Kerr's dismissal of Prime Minister Gough Whitlam exactly 50 years ago today. We were in constitutional crisis. And the power of my father's anger and upset at Whitlam's sacking must have had some serious impact on me, because I can only think that this was the moment that I developed a deep and abiding curiosity for how government and politics works and how constitutional law governs the proper distribution of power in a Westminster system. And this is because a very bad man sacked the Prime Minister 50 years ago. So I'm now standing before you as a Professor of Law giving an inaugural professorial lecture, and I guess we should thank Sir John Kerr for some things at least. But actually I do have some acknowledgements to make, because no one gets to these positions or situations alone. And as the old proverb goes, if you want to walk fast, walk alone, but if you want to walk far, you have to walk together. So I want to acknowledge all the deans and leaders of the faculty at Monash University who have supported and encouraged me throughout my career and pushed me, a little bit to hurry up. And I also want to particularly mention specifically my colleagues, Professors Paula Gerber, Sarah Joseph, Lynette Russell and Kate Galloway, who have been generous collaborators and friends to me. And I really should mention all of my excellent colleagues, particularly at Monash, but if I start, it's going to be a very, very wonderful long list. So please, Julie and Ronley and Luke and Marilyn and all of my colleagues who are joining us tonight, please accept my love and abbreviations here. And of course, I do need to mention my late father, Ron, who passed away at just 59 years old. He did try very hard to make me into a barrister. That wasn't so successful. He did instil in me the understanding that law, for all its reliance on precedent, on classifications, on doctrine, does have a liberating, creative and transformational potential which can be untapped and used for profound change. And he taught me how to think and argue like a lawyer, which can be successful in some domains but not so good in the family home. And that while individual incremental wins are very important, the real goal is systemic progressive change for justice. A special mention also to my family who are here tonight. Thank you, Mum, Lindy, Stephen, love you, and their families who are also joining us. And a very inadequate thanks to my husband Robert and children Maddie and Theo, who have supported me and learned lots of lessons about the law along the way, and so they have escaped the clutches of law and none of them have a career in law. And we're very happy about all of that. I want to also mention that my parents' families were new Australians. They were immigrants from Eastern Europe who wanted to start fresh lives in a new nation. My mum, Nellie, was born in Kazakhstan after her parents fled Warsaw on the eve of World War II and travelled across Soviet Russia to relative safety. But after the war, they discovered that except for one sole sister, their entire family, parents, grandparents, siblings, cousins, had all been murdered for being Jewish. Mum and her parents were granted visas to Australia in 1951 after 6 years in refugee camps in Europe. They finally got a visa. The one sister that lived was given a visa to Canada, and so their family split across world hemispheres. My father's family arrived in Australia from Ukraine in 1927, fleeing pogroms, starvation and poverty, occurring mostly after the 1917 revolution. My father was the first of his family to go to university and he became a barrister in the mid-60s. I don't know how it was that this Jewish Russian family from somewhere near Mariupol decided to come to Australia 100 years ago. I can't imagine what the thinking process must have been there, but that's what happened, and origins are important. So when life meets law, well, I didn't really know anything of Whitlam's government as a child. I just have the core memory of this catastrophic event that took place. But there are a lot of lessons to be drawn from Whitlam's election and the 3 years of government and then the dramatic dismissal. And one of the most interesting aspects of Whitlam's term was his determination and his sense of urgency to bring Australia into modernity, and his use of the law and the legal processes to drive forward sweeping social reforms that were so overdue. So much of the framing of our current law is thanks to the reforms that were set in place by that government. For example, the abolition of the death penalty, the amendment to the Electoral Act to lower the voting age from 21 to 18, the establishment of this Australian Legal Aid Office and the Law Reform Commission, the consumer protections in the Trade Practices Act and the establishment of the Trade Practices Commission, which was the predecessor to the ACCC, the establishment of a Royal Commission into Aboriginal land rights after the loss of the Gove land rights case, and the historic scenes of Whitlam promising the Gurindji people their title for their traditional lands in the Northern Territory, the enactment of the Racial Discrimination Act to ratify the International Convention on the Elimination of All Forms of Racial Discrimination, and the removal of the formal selection criteria underlying the white Australian immigration policies, and the Family Law Act establishing no fault divorce, and the list goes on. I've just chosen my favourite bits. But when Whitlam took office, he held a majority in the House of Representatives, but without control of the Senate, and this became the source of the drama that ensued. And when Whitlam was sworn in first as Prime Minister, his Deputy Prime Minister was Lance Barnard, and the two of them were sworn in early, and the two of them formed a two-man cabinet who ran 27 portfolios between them for 2 weeks before the full cabinet was finally determined. And during those 2 weeks, Whitlam sought to fulfil as many campaign promises as he could that did not require formal legislation to go through Parliament. So another list. He ordered negotiations to establish full relations with the People's Republic of China. The existing defence legislation allowed the Minister for Defence to grant exemptions from conscription, and so Barnard just exempted everybody from conscription immediately. Whitlam then arranged for the freedom of 7 men who'd been incarcerated for refusing the conscription. They reopened the equal pay case that was pending before the Commonwealth Conciliation and Arbitration Commission, and that was led by the then Sydney barrister Mary Gaudron. Barnard eliminated sales tax on the contraceptive pill and announced grants for the arts and barred racially segregated sports teams from playing in Australia. It was a very busy couple of weeks for this two-man government. But Whitlam showed us the classic example of crash through or crash, and actually he did both. He crashed through and then crashed. The rapid pace of change and the public excitement caused by these reforms was destabilising and certainly created a backlash. But I don't think it was the social and legal reforms that caused the downfall of the Whitlam government. The events leading up to the dismissal on this day, 50 years ago, are well explored by others. It was the sense of chaos, controversy and scandal that came to undo the Whitlam government. But many, many aspects of those Whitlam reforms remain in place as the underpinnings of our social and legal framework today. For instance, a Department of Aboriginal Affairs was established, as was legislation on human rights and environmental and cultural heritage. And there were fundamental changes to tertiary education fees, to laws on sexual discrimination, arrangements for maternity leave and benefits for single mothers. All of these became part of Australia's social fabric. And it's said that in 1973, 221 acts were passed, which is a massive record. So, although some of you here remember these reforms and the impacts of the Whitlam government, many people were too young to actually be aware of the immense change that Australia went through in the early 70s. And many of the reforms that were put in place were retained by the Fraser government and subsequent governments. Over time, some have been eroded. But Whitlam's approach to law shows us how law caught up with life. Australia was ready for modernity. Now, I want to take a step back a few years. In 1968, the Australian anthropologist W.E.H. Stanner discussed the cult of forgetfulness that was practised on a national scale in Australia in his ABC Boyer lectures entitled After the Dreaming. He dubbed this the Great Australian Silence. This was a silence in which non-Indigenous Australians not only refused to acknowledge the brutality of colonialism and the disease, massacre and dispossession that accompanied it, but also chose not to think about First Nations people at all. From this perspective, the cult was an intentional effort by non-Indigenous Australians to disregard or forget the history and accomplishments of Indigenous Australians, as well as stifle any viewpoints that ran counter to the widely held narrative of heroic pioneers taming a savage land and creating a modern nation. And this deliberate forgetting was sustained for generations, dominating at least the first and much of the second half of the 20th century. And we still see many manifestations of that today. Stanner's silence was both structural and literal. For much of the last 200 or so years, popular depictions of Australian First Nations people were filled with negative stereotypes. And the continuous marginalisation and systemic discrimination of First Nations peoples in Australia were underpinned by these stereotypes and misconceptions. The willful ignorance of history and the unquestioned belief in the construct of a fair go for everyone, according to Stanner, were key characteristics of this cult of silence. Stanner even went so far as to suggest that institutions and sectors, including education, the media and public policy, actively promoted the national amnesia. Perhaps the silence has broken down over the past quarter century, but it has not completely been replaced by a cult of listening. What Stanner carefully articulated was the schism that runs through Australian society, one that marked a significant and enduring fault line. And that fault line runs through our law and social structures today, and its effects are still very tangible. The truth of our history and the obligation to embrace this remembering and then the repairing are only partially addressed even today. And as a scholar in the field of law specialising in Indigenous issues, I've sought one main thing, and that is to be able to assist in the building of proper legal relations with Indigenous peoples in Australia. Now, this ambition is very elusive. Sometimes it can be fulfilling, but my aim really is to be constructive and to try and build justice in our national communities. And I think this is a legacy instilled in me by my late father, but also many inspirational Indigenous people who he worked with and who I now also know. When Ron was speaking about what motivated his work in advocating for Indigenous people, he said this: What was the meaning of my determination to do my part, never to permit a future destruction of the Jewish people, if I stood by and participated in the bounty and opportunity of the Australian nation? What would that mean without doing something to expose and expunge the legal lie that lay at the foundation of the dispossession, disempowerment and attempted destruction of an oppressed group of fellow Australians? I don't try and speak for any Indigenous people, but I do seek to speak with them, and I try to listen to them. And with listening comes knowledge, understanding and respect. So my obligation, I feel then, is to use the power of my knowledge and of the Anglo-Australian law to be able to criticise the law, shape the law and improve the law as it applies to all people, but more especially the first people who have suffered so much under the law. And there have been many others working in similar fields to me and across so many other areas of social justice and community and in education. It is a constant process. You can call it justice, you can call it peace building, you can call it reconciliation. But without discussion, there can be no reconciliation. Without goodwill, there can be no reconciliation. And without relationships, there can be no reconciliation, which is why reconciliation has only partially succeeded or moved in Australia. We need a lot more listening, discussion, compassion and goodwill. So, back to when life met law. Some 13 years after Whitlam's dismissal in the late 1980s, I was asked by Ron to assist with some legal research on a land rights case. Friends, I was a law school dropout. During a prolonged break, as they say, from university studies, I worked with my partner Rob as a legal intern on the Mabo case in hearings before Justice Moynihan in Brisbane, where the court there was determining the findings of fact that had to be established in order that the case could go before the High Court to proceed on the legal issues. We supported the plaintiff's legal team of Castan, Keon Cohen and McIntyre, assisting with the historical research, taking evidentiary statements from Islander witnesses and arranging logistics such as how to travel from the Torres Strait to Brisbane, which was not easy. After that work concluded, I saw that there might be some point in completing my law degree. So I went back and graduated from Monash University. And as you correctly pointed out, the Mabo case formed the foundation for my own pathway into a career in the law and in legal education. Now, of course, I recognise that the case itself, whilst groundbreaking, did not fix everything, and how could it? But it did address the fracture that I mentioned earlier. The legal claims that Captains Cook and Phillip had made to the Australian Territory showed no concern for the proper legal relations with any of the hundreds of different tribal nations that had both legal and practical sovereignty for tens of thousands of years. Cook did not see the complex kinship networks, the social rules, the rights and obligations that controlled people's lives. He saw no ownership and he saw no law. Phillip had a slightly more nuanced and complex relationship with the Eora people in Sydney, and particularly with the warrior and diplomat Bennelong. But overall, the opportunity to understand First Peoples was lost in the rush for colonial expansion and the taking of land and resources. Laws that justified and supported these acquisitions followed rapidly, and this created the deep fracture or fault line in Australian law. At first, this was politely described as a legal fiction, but later commentators refer to it as terra nullius. This was the imagined state that removed Indigenous people from the land, allowing the British to assume for all legal purposes that Australia was practically unoccupied before Cook and Phillip staked their claims. The British claims to the territory did not meet the standards set by the British themselves, nor did they meet contemporary standards, legal or otherwise. They differed markedly from the way the British settler colonialism played out in North America and in Aotearoa, New Zealand, where treaties were sought, though usually dishonoured later. Basically, if Australia was deemed to be terra nullius, there was simply no requirement for a treaty or agreement in order to purchase land. And that fault line meant that Indigenous people were invisible in law and persisted until it was expressly addressed in 1992 in Mabo. So the ruling by the High Court, as we know, rejected the legal fiction that the Australian Territory had been unoccupied before 1788. But the ruling only identified the fracture rather than fixing it. Consequently, the enduring impacts and dire consequences of colonialism have not really been remedied. The High Court recognised that the unique property rights argued by the Torres Strait Islander claimants made for the recognition of their land rights were legal rights as against the whole world. And as Justice Brennan wrote, whatever the justification advanced in earlier days for refusing to recognise the rights and interests in land of the Indigenous inhabitants of settled colonies, an unjust and discriminatory doctrine of that kind can no longer be accepted. So the decision opened the door for Aboriginal and Torres Strait Islander land claims beyond the existing land grants legislation, such as we saw in the Northern Territory's Aboriginal Land Rights Act. Native title was a land claim that came from the time before Cook and which could be recognised and enforced by contemporary First Nations peoples in certain constrained situations. The decision was also a landmark because it retained the central principles of Australian land law, resources law and property law systems, and reaffirmed the constitutional basis of the Australian nation while allowing for the recognition of Indigenous title rights and interests in land and waters. It opened the possibility of pluralist recognition and proper legal relations. Now, as I haven't stopped telling people, I've just returned from a 2-week study tour in Canada with 15 Aboriginal and Torres Strait Islander leaders who are completing their Masters of Indigenous Business Leadership at Monash University. Now, I had previously had the privilege of teaching these students in a unit called Indigenous Rights and International Law here in Melbourne. But then I was invited to be a co-lead on a field trip to meet Canadian First Nations, Métis and Inuit leaders, educators, elders and innovators. And we travelled from British Columbia to Manitoba and Alberta. This was a deep learning for me, but here's some of the things they told us. Reconciliation is worthless without reconciliation. Governments and businesses will talk the talk but resist walking the walk, and sometimes that walk is harder and heavier and more difficult than anticipated, but it has to be done. They also taught us about learning with the head, the heart and the ears. Sometimes when learning from First Peoples, we have to listen, think and feel. They also told us that they are working with a 7-generation time frame in mind. They are thinking of the lessons of their ancestors from 7 generations back, and they are working to improve the lives of their grandchildren's grandchildren 7 generations forward in time. Of course, they would prefer that things were better right now, but their plans have a 200-year line of sight into the future. Now, these are really interesting lessons, particularly for someone trained in the law, because we are trained to argue our way through problems. We talk a lot. We analyse fastidiously. That's what we're supposed to do. But when working with First Peoples, we need to listen more closely, seek justice and stop talking. We don't have to be right. We don't have to be certain. We can listen and then do the work. And we may not like everything that we hear. That's okay. Being uncomfortable is part of the learning. It's part of the reconciliation. If we are really to have processes for proper legal relations with First Peoples, it cannot be all on our terms. We may have to face some recalibrations of our legal assumptions. In Canada, when we were in Manitoba and other places, people described themselves as being on Treaty 1 lands. This referred to Manitoba's treaty between the Canadian Crown and the First Nations, signed in 1871. This was the first of the Canadian historical treaties, and it now establishes the framework for reconciliation and ongoing legal, political and governance arrangements between the First Nations and the Canadian government. That brings me to the treaty in Victoria. We are on Treaty 1 lands here now. The treaty is the first to be signed by the Crown in Australia ever. So this is a most significant step in the establishment of proper legal relations between First Peoples and the state. Well, how is it going to work? It starts by establishing new institutions that are quasi-constitutional. They're quasi-constitutional in the sense of constituting the established principles of public power that govern a state. It makes an adjustment to the arrangements of how the state is run. Public law has shifted in Victoria. The statewide treaty legislation establishes 3 new public institutions in Victoria under a new authority called Gellang Wall. I won't go through all the details. There's a lot of detail. I'd love to discuss that with you. Call me back for another time and we'll have that discussion. But I do want to draw attention to a key change. The treaty and the act that frames it creates a mandatory consultation obligations requiring ministers and departments to consult with First Peoples Assembly on laws and policies that are specifically directed to First Peoples. The Assembly will also make representations and provide advice to government with the capacity to ask questions of the minister. This advisory function mirrors aspects of the proposed federal voice to Parliament, but it situates it within a body that also possesses substantive decision-making powers in specific domains that are relevant to First Peoples. So in this sense, the functions that I'm describing operationalise the UN Declaration on the Rights of Indigenous People, which Australia agreed to in 2009, particularly Articles 18 and 19. And those articles establish Indigenous people's rights to participate in decision-making and to be consulted in good faith before the adoption of measures that may affect them. The treaty also meets the requirements of Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, which are the foundational international human rights law which Australia signed on to nearly 50 years ago. And of course you can read my book with Sarah Joseph on that in any one of 900 libraries around the world. The consultation requirement in the Statewide Treaty Act does not grant First Peoples Assembly veto power. The ultimate decision-making authority remains with the Victorian Parliament. Parliamentary sovereignty remains, so there's now a procedural obligation to engage with the Assembly before advancing First Peoples specific legislation or policies. Victoria's approach represents a genuinely significant advance in realising self-determination for First People within our constitutionally conservative Westminster parliamentary system. The statewide treaty model demonstrates that meaningful Indigenous self-determination can coexist with parliamentary sovereignty, democratic accountability and the rule of law. And while statutory in nature, the Victorian framework provides First Peoples with genuine authority over cultural, community and policy matters that directly affect them. It's a practical exercise in self-determination that transcends just symbolic recognition. Okay. It's over 30 years since the Mabo case, but more Aboriginal people are homeless and displaced from their country. It's over 25 years since the Bringing Them Home report on the stolen generation was handed down, and 17 years since Prime Minister Kevin Rudd's apology in Parliament. But now there are more Aboriginal children removed from their families and in inappropriate state foster care than ever before. It's over 30 years since the landmark report into the Aboriginal deaths in custody was delivered, and 8 years since the Australian Law Reform Commission reported on the national problem of over-incarceration and criminalisation of Indigenous peoples. But Indigenous people are still dying in custody every month in Australia. And as I mentioned, it's over 15 years since Australia agreed to the UN Declaration on the Rights of Indigenous People. This year we saw the completion of the first Australian Truth-Telling Commission, the Uruk Justice Commission here in Victoria. And it's just 1 month until Australia's first formal treaty with Indigenous people will come into force. Dozens of other inquiries, all with deep consultations, carefully developed, culturally informed recommendations are all sitting on the shelves of government departments gathering dust. It's not as if we do not know what has to be done. Aboriginal and Torres Strait Islander people have told us, traditional owners and historical communities have told us, and the nationwide Indigenous-led Uluru Dialogues have also told us. But we have failed to convince Australia that giving Indigenous people a voice and listening to their views was worthy of national support. Nationally, Australian people wouldn't even agree to give Indigenous people a voice, so we failed that test. Governments continue to let down the Indigenous people of this country, but governments are voted in by people of this country, and so we all have to do better. First Peoples deserve better, and Australia must be a better country. It's our roles as lawyers, as law students, and as law knowledge holders to do this work. The Victorian Treaty is a tremendous example where law and life come together. I'm very optimistic that there will be more than one treaty in Victoria and in Australia. And I hope in 7 generations, our grandchildren's grandchildren will be celebrating with the First Peoples of Victoria, Treaty 1, and all the other treaties that follow. Thank you.
I sent the middle factual bit of my introduction to Melissa a couple of days ago and said, can you just fact check what I'm saying? And she wrote back and said, yes, the facts are all correct, but not too much gush, was what she said. But that's the whole point of these inaugural lectures. It is a public opportunity to gush and to be proud. And what you did then was very typically you. It was brilliant, it was warm, it was inclusive, it was gently confronting, which I enjoyed. So congratulations, Melissa. When I think of Melissa's work, there is an eco-philosopher called Joanna Macy, and she writes about the need for us to practice active hope. And I think that's what your work does and what you give to us and will give to many future generations. Many congratulations.